Guys, one attorney points out that Mr. McHenry allegedly had no idea that about $500 a month was being withdrawn from the couple's accounts.
Ms. Van Dyken's order says the defendant can't reside in his brother's home. That's not true. He has to reside there right now until he can get money to buy a home. It's that he can't have overnights there with minor children. So that's a clarification as well. And then finally, it just needs to reference. Sorry, I'm looking for my notes. Got messed up here. Oh, that the provision is and this is on the record in the transcript as well, but this is intended to be part of the final judgment of divorce. And that should be in the order as well, because that's what is on the record. So other than that, we want to get a motion order entered. We've been wanting to. So that's the only issue are those things.
Well, as you know, under the court rule, the question for the court is, does the proposed order comport with what's on the transcript or on the record? So
right, and the things I just mentioned is exactly what Ms. Van Dyken's order does not comport with on the record.
Okay.
No, you were saying you had other agreements with Mr. Worth. Those were not on the record. So we did an order pursuant to the transcript that I sent to you back in January, and this is the first I've heard of these other issues. So my order does comport with exactly what was placed on the record via the transcript, which was attached and sent to you.
Judge, everything I just said is in the everything I just said is in the transcript. The only things that are not are the tax issue and the starting weekends, which I already said we're not here to argue about. We won't include those in the record. But everything else I said is in the transcript. The one of them is page 8, lines 4 through 8. The other one is
so let's take them one at a time. Ms. Van Dyken, do you disagree with that?
Your Honor, I apologize. I'm out of the state and I don't have access to all of my screens, so I'd have to go back.
Okay.
What are the lines 4 through 8?
I can share a screen if you'd like, Judge, to this transcript.
That's probably a good idea. Go ahead.
Yeah.
So as far as one of my points was, we will
hold on a second. Let's my screen went. I don't know. Can you see it, Ms. Van Dyken?
I can, Your Honor.
Okay, that's good.
Yep.
It's just huge on my screen and it took up more than I got it. I have it fixed now. Go ahead.
I have a tiny screen so I can see it.
Okay, good.
So here we're talking about the Hague Convention, at least that's what that was meant to say, and other statutory provisions regarding domicile residence and other customary language that we would see in a judgment of divorce. For example, inherent rights provisions, right? That was in our proposed order. It's not in Ms. Van Dyken's order. Right here, as we go on to the next lines 9 through 13, and provide to this court that it's the party's intention that these terms would be merged and incorporated into the final judgment of divorce. That needs to be in the order. That's not in Ms. Van Dyken's order. This, in the next sentence, this would resolve all pending motions that are before the court, and it supersedes any other agreements. That needs to be in the order. It's all right here in this first part. And then my last one was the brother's home language, which was defendant can reside there, but the children can't have an overnight there.
And where is that in the transcript?
Sure, let me search for brother. The no contact doesn't have to do with the brother's home, only the mother's home, because there's no contact with Mr. McHenry's mother's home. And then there are no overnights at the brother's home. And I think there's one other section on this, so let me know if you want me to go to that section.
Ms. Van Dyken?
I can put that in the order, that there's just no overnights. He doesn't have overnights now, so that's fine.
Okay. And
I can add the inherent rights. Yeah, I can add the inherent rights.
Okay.
And the merge. That's fine. I can do that today.
Okay.
This is, again, the first I've heard of this.
All right. Mr. Barnett, does that take care of your concerns with the proposed order?
Yes, Judge.
Okay. All right. I think that takes care of that issue then. We'll move on to the next one. So the order will enter with those amendments.
Thank you. I believe I filed the next, also an objection to discovery that was sent early February, Your Honor, which is far past our discovery deadline. We had a settlement conference on January 8th.
The attorney explains that the transcript shows something very specific. Mr. McHenry is allowed to live there temporarily, but the children are not permitted to stay overnight at that location.
Where Mr. Barnett had elicited that he had previously sent interrogatories to Mr. Worth, but I said, I don't believe those came to me when I got Mr. Worth's file. Well, a month later, early February, Mr. Barnett actually says, well, oops, I didn't really send them. There was a kerfuffle in my office and they didn't get sent. Well, they didn't get sent long past the discovery. I was willing to answer those that he had sent during the discovery deadline. We are 30 days from today away from trial. I am starting trial prep. I am not about going back and doing discovery and depositions that are scheduled one day before trial and the day of trial. That's not necessary. We also have mediation coming up on March 17th. I'm hoping we can resolve those issues then. But this is you don't keep doing discovery throughout this case. There's a deadline, there's a reason for a scheduling order. My client and Mr. Worth, previous counsel, and myself have followed that. And now they want to just go on a fishing expedition. So I'm objecting to the demand for admissions, the interrogatories, and the depositions at this time, because we are in trial prep mode. Thank you.
Mr. Burnett.
Thank you, Judge. I have no problem withdrawing the request for admissions because they really had to do, I was hoping to get that done in lieu of the motion regarding the business. I have no problem withdrawing those as to that issue. As to the other issues, Ms. Van Dyken is correct in that, you know, we had a status conference with Your Honor. I had thought discovery responses went out. We did have a changeover in our office here. That's not anyone else's fault but mine. I take responsibility for that. And it took a minute to figure out between that and then me being in court for a few days. Took a little bit to figure out. Once I figured out that we didn't, rather than try to fight, or rather, I don't even know if we did or not, but the person who's no longer here, I don't have that answer. So once I figured out that I couldn't prove that we did, I redated them and submitted them. We did cite some law, Your Honor, that says when a party has a change of counsel, there is good cause to extend. This is the first to ask for a discovery extension in this matter. This matter is not an old matter. If we were to go to trial in March, Your Honor, if we do go to trial in March, we're still well under the year deadline. But more importantly, it's necessary for you to understand the extent of the marital estate, Your Honor. And we can, if things need to be refined, I have no problem with working with Ms. Van Dyken on that. But let me give you a couple examples. Mr. McHenry had no idea Ms. McHenry was taking out $500 a month in additional monies from the party's accounts. That's been discovered. We have no idea where that money is. Maybe it's gone, maybe it's nowhere, but we have the right to discover that, and we have the right to understand the extent of the marital estate. Another issue is during the party's marriage, the money that Mr. McHenry earned in the business paid the bills. Ms. McHenry's money that she earned was supposed to go into a separate account, kind of like a savings things for the parties. We don't see that money anymore. We don't know where it is. And maybe it is somewhere, but I don't know where that is. And it's not fair for Mr. McHenry to go to trial on that note. I'll give you one more final example is Ms. McHenry's family pays for a decent amount of things for her, and that's fine. But when we're going for child support purposes, Your Honor, if there's, the child support formula is very clear on this. If there's recurring gifts that add to the benefit of the children's lives, then that needs to be at least considered as to child support calculations in the future. We need to understand these things. So I would ask for discovery to be extended. And I would also note, as we did in our motion, that the way that Ms. Van Dyken has gone about this gives you no authority, Your Honor, under any court rule or jurisprudence to not allow the discovery to be entered. She didn't follow a proper mechanism as well. And I'll just stick at that, Your Honor.
Mr. Barnett came into this. Mr. Barnett, when they changed over, he's been on this case since I believe last September. And so I don't know what the delay of discovery was. I just came into this case in December. So that is, a changeover in attorneys happens. There is law and authority. It's the scheduling order that this court issues, and we follow those. When orders are said and in writing, we follow those.
So when,
Your Honor, can I just one real quick thing, please? I'm sorry.
no, go ahead.
Thank you. Ms. Van Dyke's not wrong that I was in since September, but we worked incredibly hard on trying to settle this case. And we did come to the parenting time settlement. That happened within the first few weeks. That was the primary focus. Then we had this business valuation thing that we were working on very hardly, and we almost settled this case, Your Honor. And that was the delay in discovery.
When did you discover, okay, when did you discover these issues that you're now inquiring about or want to inquire about?
About late December, which then again, I had mid-December, and then that's why we sent the discovery request, or at least I thought I did. Then we found out we had the settlement conference. I didn't, and then a few weeks later we did send reissue
that timeline doesn't work, Mr. Barnett, because you said you had sent discovery to Mr. Worth. I was in this case in December. So if you had sent them in December, you would have sent them to me, but you didn't send anything.
No, Ms. Van Dyke.
That timeline doesn't work.
It does work though, because these recent issues are just examples, Judge, of why we need to know the extent of the marital estate. That you won't find a discovery request specific to the $500 a month or anything, because I didn't know about it when we drafted their discovery request. But I wasn't going to add that to new requests when I had already represented to you that I sent the version that I represented to you that I sent, or that I had thought that was sent.
I will extend the discovery deadline, but only on a very limited, to a very limited extent. So you're going to have to go through your discovery that you have sent and pare it way down. And there's going to be no deposition on the day before trial or the day of trial.
Understood.
All right.
Opposing counsel challenges the timeline presented by Mr. McHenry's attorney, pointing out inconsistencies about when discovery was supposedly sent.
And is there anything else on that issue?
Just so I'm clear, so you want me to pare it down, resend the discovery, and restart the clock? Okay.
And it's going to be, pretty short here. So we're not going to run right up to your mediation. It's all got to be taken care of before that. So again, very short, very pointed, get the information that you're looking for without going far afield.
Okay, I'll do that. I will get it sent out today.
All right. And then, does that take care of everything? You still have something else?
Ms. Van Dyken has the transfer of the escrow.
Transfer of the escrow of the home proceeds from Mr. Worth's account to either my account or Mr. Barnett's account. I don't know what the objection to that would be. Why would we leave it in an attorney who is no longer on the case? Mr. Barnett, it was fine leaving it with Mr. Worth. My client is not. That's her former counsel.
Okay. Mr. Barnett?
My only request was that we get monthly accountings, and my only reason for not agreeing to this off the bat was Ms. Van Dyken won't respond to me. It's really hard for me to convince my client to move the money to somewhere where I can't talk to opposing counsel.
All right, we'll put it in Mr. Barnett's account.
And we could include that Mr. Worth will provide an accounting of it as well.
Of course, yes,
Yeah.
yes, absolutely. Anything else?
Yes, Judge, I have my motion.
Okay.
We took care of the discovery. So then one of the things would be the proceeds from the marital home. We've asked that each part, so there's around $250,000 in that account. I've asked, Mr. McHenry's asked that each party take $45,000 from that. And his sole request is, as you heard, Your Honor, he can't exercise overnights until he gets his own home. He needs money for a down payment on his home. And it's as simple as that. So he's asking both parties take the exact same amount, the rest remain in escrow.
Ms. Van Dyken?
We would object to that, Your Honor. This court can't divide property division before a judgment is entered. And quite frankly, we don't know where this is going to come out with this business valuation and things of that nature. So I don't know where those funds would go. What would be who would be getting more or less. There's a bunch of funny money that's going on with the business at this time. So I would ask the court to reserve that until we're 30 days away from trial. And maybe we can talk about it at mediation.
Mr. Burnett?
So the spring market's going to kick up. Market's going to get more competitive. Mr. McHenry wants to start externizing overnights with his kids. It's fair and it's equitable. There's still money left over. If there's a decision about the business, Judge, I don't know why that affects the sale from the marital home. Ms. McHenry has been able to move out, get a new home. Mr. McHenry has not. And he needs one. He needs to be able to provide a good home for his children. And Ms. McHenry will not agree to allow overnights at his current residence at his brother's. I don't know how it's not fair to give both parties the same exact money so he can get a house for him and his children.
Well, we are very close to trial. We're closer to mediation. I'm going to deny the request at this time because, again, there's so many moving parts here, and the court generally does not divide up property without knowing the whole picture.
Okay, thank you, Judge.
All right, thank you.
Then we have just two more issues. One, the easier one, I think, is the communications with the minor children. So Mr. McHenry has been blocked on his children's devices for quite a while, and in their response, Ms. Van Dyken says that, well, that's because no order's been entered. Well, that doesn't make sense. He's been exercising parenting time ever since we agreed on the record. And on the record, Judge, in the transcript, you'll see remember, that was supposed to be of immediate effect. All he's asking is that the children become unblocked from the mobile devices. He wasn't even able to say happy birthday to his children, Your Honor.
Ms. Van Dyken?
Your Honor, the no contact order wasn't lifted in that order. And it's no contact not only with the kids, but with Mrs. And those are the devices that she communicates with the kids for. She just doesn't wish to have him have that communication while at her home.
See, and that was a problem, Your Honor, because as we already looked at the transcript today, it does say it supersedes the previous orders, and it was to take immediate effect.
I'll grant the request, but Mr. McHenry is not to address anything to Ms. McHenry in any of the texts or calls that he makes to the children.
Understood.
Okay.
Do you mind if I ask my client real quick to make sure that he heard what you just said?
Okay, no, go ahead.
Rodney, did you hear about not addressing Sydney at all through the children? You're muted.
What was that?
Did you hear the judge said that she's granting the request to unblock your number from the children's devices, but you are in no way to contact Sydney through the children?
That's perfectly fine. I have no interest in doing that anyway.
Thank you. You can mute yourself again. And our last request, Your Honor, is just regarding the party's business. Ms. McHenry took a $20,000 withdrawal out, and opposing counsel is saying, well, he took $10,000 out to pay his attorney. But the difference is this: throughout the party's marriage, Mr. McHenry always would split the money coming in from the business one way and one way. He has continued to do that per the mutual restraining status quo order. So he can take his money to pay for it, but when she gets money per the status quo order and then takes another $20,000 and empties out the business account so it can't meet its needs, that doesn't work. I understand Ms. Van Dyken has some contesting or contest as to how Rodney is spending the business money. I think that's fair, and that can be worked out on the back end. That absolutely okay. So we're agreeing this isn't a business expense. This comes out of, Mr. McHenry's share of the marital estate. Those arguments are all preserved, and rightfully so. And I understand Ms. Van Dyken's concern there. But Rodney has always run the business, and he needs to be able to do it without having an unauthorized withdrawal from Ms. McHenry. And that's all we're asking, is that Ms. McHenry would refrain from any withdrawals. She's receiving her monthly payments from the business.
Ms. Van Dyken.
Let me be clear. Let me start with that. Your motion says she gets 5,000. She doesn't get 5,000. She only gets like 2,200. They split the 5,000 after taxes. As to access to the account, Your Honor, the parties during the marriage, she ran the front end of the business. He runs the back end. They've always run this business together. He not only took 10,000, he took about 21,000 to pay his attorneys and for other things. Not only Mr. Barnett, his former counsel, and his new drunk driving counsel, I'm assuming. And my client took the exact same amount, I think maybe $700 less, to pay her former counsel. So they've both been accessing that account for personal use. I think my client, I would agree that there should be no more funny money. Nobody's paying other attorneys. It should be stuck with the business. But my client needs access to ensure that he's not doing anything with those funds. So I would stipulate that neither party will pay personal expenses out of that account other than what they're receiving from the monthly disbursements. But she still needs access to keep an eye on what's going on.
Mr. Burnett, does that satisfy?
Yes, that satisfies the,
That's
oh,
fine.
sorry. Is this? My client seems to want to confer with me on something, Judge. I don't know if you would allow that or not. If I could call him real quick.
Yes. Ms. Van Uller, would you?
The court addresses money from the sale of the marital home, currently sitting in escrow. Mr. McHenry asks for $45,000 from the funds so he can put a down payment on a home and begin having overnight visits with his children. Finally, the attorneys discuss withdrawals from the family business account. The judge encourages both sides to stop using those funds for personal expenses while the case moves toward resolution.